Good afternoon, and welcome to the webinar, How the National Mortgage Settlement Impacts Communities of Color. Hi, I'm Ann Price, Director of the Closing the Racial Wealth Gap Initiative at the Insight Center. I want to take just a minute to tell you a little bit about our work and why we are focusing on the mortgage settlement this afternoon, and then I'll turn it over to our moderator, Janis. First, just briefly about our organization. The Closing the Racial Wealth Gap Initiative is housed at the Insight Center. The Insight Center is a national research, consulting, and legal organization dedicated to building economic security and opportunity in vulnerable communities. We work in the areas of asset building and income, workforce development, minority and women-owned business enterprise, and we also provide legal technical assistance. Our Closing the Racial Wealth Gap Initiative is a national effort to address the wealth gap that leaves the average American family of color with only 5 cents for every dollar owned by the average white family. To close the gap for the next generation, we have brought together a network of over 175 scholars, advocates, and practitioners of color to inform national economic debates with diverse perspectives, and to also provide solutions to create a more inclusive and equitable future for all Americans. We have 2 of those experts participating in this webinar today, both Janis and Jim. Just to tell you a little bit about what we're doing, we're educating the media and policymakers about the magnitude of the racial wealth gap and why it's so important for the economy to close it. We're injecting the voice of experts of color into popular and policy discourse to show how these policies impact communities of color. We're producing innovative and groundbreaking research that informs policy development and we think leads to practical, sustainable solutions. And finally, we're providing policy recommendations to address the racial wealth gap. We are hosting this webinar today because we are facing the greatest loss of wealth among communities of color in modern American history. And we're seeing the largest gaps in wealth between communities of color and white since we've been collecting data on assets. Since home equity represents about 65% of the wealth among communities of color and is often the major vehicle in which these communities provide opportunities for their children and themselves, the foreclosure crisis has been devastating. We know, for example, that including home equity, Latino families with children have lost about 72% of their wealth in just the recession years alone. We know that now communities of color are running the great risk of continued credit deprivation and economic stagnation. They are facing significant constraints on access to credit, and they're struggling with the legacy of subprime lending and high levels of unemployment. We know that this wealth will not be easily restored in a generation, and there's really no easy return to normal. With that, we're going to explore how the mortgage settlement may impact communities of color as they begin to climb out of what we see as a deep hole to even regain the same footing they had before the crisis. Before I turn it over to Janis, I want to remind listeners to type in any questions you may have for the Attorney General, for Janis or Jim. In the question box on the right hand of your screen, you can do that throughout the webinar, and those questions will be addressed at the end of our discussion. And I also just want to thank the staff of Global Policy Solutions for their work in putting this webinar together and helping us organize this webinar. With that, I'm going to turn it over to Janis to moderate the panel.
Thank you very much, Ann, and good afternoon to everybody on the phone. I'm Janis Bowdler. I'm the Director of the Wealth Building Policy Project at National Council of Raza. And like many of you, we have been deeply concerned about the state of our families and neighborhoods in the wake of unprecedented foreclosures and really the worst recession since the Great Depression. I want to thank everybody on the phone with us today for taking time out of your schedule for a timely conversation about what the 49-state AG settlement means for communities of color. And I would like to thank our speakers in advance, Jim Carr, Chief Business Officer at the National Community Reinvestment Coalition, and Attorney General of Maryland, Doug Gansler. No doubt many of you recall how we got here. It was about a year and a half ago that reports started to surface of a wide range of servicer abuses. In a rush to process foreclosures as quickly as possible, servicers were botching paperwork and they wrongfully foreclosed on families, on homeowners, on our vets. AGs around the country rushed to investigate the troubling news. I will say it took longer than some of us would have preferred, but we are very excited that the AGs have successfully negotiated with the nation's 5 largest servicers, and it couldn't have come at a moment too soon. Today, CoreLogic estimates that 11 million homeowners are underwater. That means they owe more than their home is worth. An estimated 17% of Latino homeowners and 11% of African American homeowners have already lost their home or are at risk of losing their home soon to foreclosure. This landmark victory will be a lifeline for struggling homeowners that have been waiting desperately for justice, accountability, and meaningful relief. I'll leave the specifics to AG Gansler. I don't want to steal his thunder, but I can't help myself but say that one of the most important things in this deal is that the 5 largest servicers have agreed to reduce principal loan balances. This has been the vital missing ingredient that has resulted in so many other federal programs coming up short. Some advocates have expressed concern that $25 billion is not enough to forgive the sins committed in the housing market. This is certainly true, but we must also keep in mind that this is just one settlement action on a narrow issue. Speaking for NCLR, we hope to see the investigations continue, particularly in the area of origination abuses. In the meantime, it's my hope that this settlement will be a blueprint for further accountability measures and for taking principal reductions to scale. There's certainly much to discuss on this topic, so to get us started, Jim Carr will share a brief overview of the impact of the foreclosure epidemic. Then we'll turn it over to AG Gansler to share his perspective on what relief the AG settlement can offer our families. After these opening remarks, I'll take a few questions and then we'll open it up for discussion. If you have, as Ann mentioned, if you have questions as we go along, please feel free to send them to me via the web chat function on the right of your screen. I'll summarize a few of these questions when we kick off the Q&A. And so with that, Jim, let me hand it over to you.
All right. Thank you, Janis.
Good afternoon. In the fall of 2006, the Center for Responsible Lending released an ominous estimate, the possibility of 2.2 million foreclosures. What seemed to some observers to be an overstatement of the problems brewing in the housing market would later prove to be a conservative estimate of the foreclosure crisis to come. The initial spark that set the foreclosure crisis into motion was the saturation of the mortgage market with predatory loan products and reckless and irresponsible underwriting. Failure by federal policymakers and regulators to implement or enforce meaningful loan modifications allowed the crisis to continue to grow and expand. The result was that by the latter part of 2008, the foreclosure crisis had dragged the U.S. economy into the worst recession since the Great Depression, and unemployment took the top spot as the leading cause of the loss of homes. Borrowers opting to default on their loans also became a growing problem as home prices sank nationally by more than 30% and in some markets by more than 50 or 60%. Since the beginning of 2007, CoreLogic estimates that more than 10 million foreclosure filings have occurred. Although the majority of foreclosures have been experienced by non-Hispanic white borrowers, people of color have suffered a disproportionate share of the loss of homes. The Center for Responsible Lending estimates that African Americans and Latinos are twice as likely to be seriously delinquent or have experienced a foreclosure. And as recently as November of last year, CRL estimates the crisis is not halfway over. At least 22% of all mortgages are now underwater, meaning that a mortgage is of greater value than the price of the home it secures. Yet the Woodstock Institute estimates that in the Chicago area, African Americans and Latinos experience twice the level of negative equity as white borrowers. Importantly, the Woodstock Institute's findings are likely reflective of the reality of negative equity in African American and Latino communities throughout the country that have experienced large numbers of foreclosures. The homeownership rates for African Americans and Latinos have fallen significantly, with blacks experiencing the sharpest decline. In fact, the homeownership rate for African Americans actually peaked in 2004, with foreclosures already devastating many of those communities. But rising home values helped to mask the full extent of the problem that was already underway. A study by the Pew Research Center last year quantified the loss of wealth for people of color as a result of the foreclosure crisis, estimated that between 2005 and 2009, Latinos had lost a full 66% of their wealth, Asians 54%, and African Americans 53%, compared to a 16% decline for non-Hispanic whites. Looked at another way, the wealth gap between African Americans and non-Hispanic whites, for example, that was roughly 10 to 1 for almost 20 years, has now jumped to 20 to 1. A similar increase in the wealth gap has occurred between Latino and white households. The majority of wealth loss was housing equity in the form of foreclosures or lower home prices. Beyond foreclosures, people of color have also borne the disproportionate brunt of a struggling economy and lingering high unemployment. African Americans and Latinos continue to experience double-digit unemployment, as well as are overrepresented in the ranks of the long-term unemployed. The damage to communities of color has been so significant that the Annie E. Casey Foundation has convened a group of more than 40 research and policy centers, as well as fair housing and civil rights organizations, to discuss and share information on the impacts of foreclosure crisis on communities of color. Of the many policy papers that have been developed as part of that effort, the Casey Foundation, in partnership with NCRC, published a white paper last year titled The Foreclosure Crisis and Its Impacts on Communities of Color, Research and Solutions. That document examines in detail the current state of the foreclosure crisis, efforts to stem foreclosures, impacts on communities, and emerging proposals to restructure the home mortgage finance system. And finally, it's important to recognize that neither the foreclosure crisis nor struggling economy are things of the past. They both continue today. It is in this context that we review the value and significance of the recent AG settlement. The agreement allocates $25 billion to a range of activities. One of the most potentially important features of the agreement is the new servicing standards and guidelines. One of the weakest aspects of the deal is that loans hit.
Back, Jim.
Okay. Another disappointing and unfulfilling aspect of the agreement is the set-aside of only $1.5 billion as payments to borrowers who experienced a foreclosure. The agreement offers between $1,800 and $2,000 per borrower, regardless of the real financial damage they incurred. Compare this figure to the 66% loss of wealth for Latino households. Having said that, no single settlement can compensate for the damage that has impacted communities of color as a result of reckless, unfair, and predatory lending. Much more needs to be accomplished than more effective loan modifications, including whether they have principal reduction and token payments for past financial harm. It is critical that federal policymakers acknowledge and address the damage that has occurred through legislation that promotes jobs, increases education and training opportunities, deals with the massive amounts of vacant and abandoned properties that literally litter communities of color, and promotes affordable home ownership. These broader issues are, however, beyond the scope of today's conversation. The AG settlement represents an important step forward in redressing some of the damage caused from predatory lending and reckless and illegal foreclosures. Ensuring that it is implemented in a fair and effective manner is also an essential step we need to ensure. And that's it for me.
Great. Thanks, Jim. And now Attorney General Gansler, we'll turn it over to you.
Okay, and I will address a little bit. I lost Jim on what he thought the weakest aspects of the deal were. I think we all did. The only one I heard was the $1.5 billion. I'll address that in a minute. It sounds like at this point in the program, most of sort of the impact of communities of color upon regarding the foreclosures themselves and the economic downturn has already been addressed. The reason why there are so many people of color who were affected by this is manifold, but one of them is the banks themselves. The five major banks and actually the originators were intentionally pushing subprime loans in the African American communities in particular, and also the Latino communities around the country. In my state, more in the African American communities, when in fact the African American borrower often had the credit history to secure a loan with better terms than were offered by the banks that were giving them subprime loans without telling them they actually qualified for a better loan. And that was just one of the types of conduct that we found, starting with the investigations in October of 2010, when all the robocalling came to be exposed. And so what happened was back in 2010, the robo-signing began, and we started to investigate, mostly on the state level with a little help from the feds at that time. We uncovered a great amount of egregious, insidious conduct that was being conducted by the 5 national banks as well as other banks. We were able to begin negotiations on how to solve this sort of litigation. I think one of the comments that was made by, I think it was Janis at the top, or it might have been Ann, talking about that it took longer than people might have wanted. That actually was because of the securitization, whether or not we were going to be able to waive any potential or future securitization claims. The banks obviously wanted us to do so. The attorneys general did not. It's really targeted a different audience. What we were very concerned with in reaching this agreement was making sure that we got immediate or certainly imminent relief directly to those affected by the conduct of the banks. And then what we'll do is, and they wanted us also to waive any claims regarding securitization, which is obviously going toward the investors and investment funds, which is a different group of people who lost money really by the same conduct that the banks were engaged in, albeit packaging together subprime loans that they knew would not be satisfied and then selling them as investment vehicles. So sticking with the agreement that was reached, and it did take a long time. There was an executive committee, a bipartisan executive committee put together by the attorneys general, and as we talk right now, there's 25 Republicans and 25 Democrats as part of NAG, the National Association of Attorneys General. We were not on the executive committee here in Maryland, but we were very involved in the negotiations, and much because I'm the president-elect of NAG and will become president of the association in June. We got very involved in it. There was a time toward the end where there were a number of states considering not joining in because the deal wasn't what we wanted it to be. You remember there were press accounts of the total package being $5 billion as recently as 50, 60 days out. It ended up being closer to $26 billion with an ability to go even higher in the future. So it ended up being an attractive resolution for all the states. The Oklahoma Attorney General has a different view of this kind of thing. I think it's more of a principle issue, not principle in terms of money, but principle in terms of what he believes are his principles. But all the other 49 states did sign on. It was really focused on, there's 4 different pools of money, as you now know. In Maryland, we were disproportionately affected by the foreclosure crisis, and therefore we ended up receiving the 6th most amount of infusion of dollars, real or write-downs into our state, about $960 million, almost $1 billion from this settlement. Bear in mind, there are now negotiations going on with the next 9 biggest banks, and by so doing, we'll really have encompassed all of, or almost all of, the non-Freddie and Fannie banks in the agreement, and then other people will get more money. And this is involving the servicers. So the servicers, what the agreement only focused on were the 5 major servicers: Bank of America, Citi, J.P. Morgan, Chase, and GMAC Alloy. So the 4 different pools, speaking from just the Maryland perspective, and you can extrapolate out to the other states, $808 million of the $959 million is going to people who, through a set of criteria, are on the brink of foreclosure. They're delinquent in their payments. There's a number of criteria used to show that they are the most likely next people to go into foreclosure. 60% of that $809 million, and I guess the national totals you have, has to go toward principal reduction. The remainder of that pool of money can also go toward principal reduction, but it can also be used for short sales and loan modifications. That is probably, if you were to rank them, the most important pool of money, because it really starts to stem the foreclosure crisis. The next biggest pool of money in Maryland's case is $64 million. that goes to people who are underwater. And you know, an example, as someone it was mentioned earlier, you have a $300,000 loan on your house. The house is now worth $170,000. But for the settlement, the banks would not allow that homeowner to refinance. These people are up to date on their payments, but they're significantly underwater such that they would most likely go into foreclosure themselves. The loan modification allows them to get a very reduced payment using today's low interest rates. And the bank writes that number down starting at $64 million, getting down to zero. The third pool, this goes to what I think Jim said was one of the weakest aspects. I would take the other side of it as probably the best aspect of it in some ways. Certainly can make the argument. The $1.5 billion nationally and in Maryland $24 million goes to people who were foreclosed upon. They're no longer in their homes. They basically get an $1,800 to $2,000 check, a windfall check, because this agreement in no way at all puts them in any different situation than they were without the agreement. So in other words, if in fact the homeowner shows through legal assistance that is available to them that but for the conduct of the banks they would not have been foreclosed upon, then that particular homeowner can get up to full restitution. So they're getting this check, one-time check, for really without sacrificing any of their individual rights whatsoever. The final pool, and by the way, that one has a deadline. The way that people have said $1,800 to $2,000. That's an estimate of what the check would be. People have to fill out their claim forms and get them back by July 31st nationally. And at that time, they'll review how many claim forms have been received, and then people will get the check based on the amount of claim forms. So the estimate is that it'll be somewhere between $1,800 and $2,000 per homeowner that had been foreclosed upon whose loans were serviced by one of these 5 banks. The remainder of the other pool is the $62 million pool, and that, in the case of Maryland, that is to be used for people for services directed by the attorneys general to help people in housing-related issues. Different states are doing it differently. A couple of the Republican states, along with Missouri, are actually putting that money in the general fund. I personally think that's not consistent with the principles that were designed in this agreement that was done to help homeowners who are in distress. What we are doing is actually what Colorado has done, which is I set up a committee with representatives from the governor, from the Speaker of the House, from the President of the Senate, from the Mayor of Baltimore and the County Executive of Prince George's, and a couple of people from my office who are working on it, to assess and take proposals for how that money would best be spent, the most effective and efficient uses. Some of it will supplement already existing government programs. Some of it would be sent to nonprofits. That group has met twice. I believe they're going to meet a couple more times, and then they'll have recommendations to me. We will never actually get the money. It's money that's put in escrow that we will direct toward the different sources. We have no preconceived notions of where that money will be spent. I can tell you in our case, because the agreement provides for up to 10% of that pool being allowed to be being considered, permissibly considered as a civil penalty, we think, consistent with the principles of the way Maryland does things, that we are going to give all 10% of that pool to the general fund. The remainder, again, I don't have any preconceived notions other than we are going to direct some of the money, and how much I don't know, that's for the committee, toward housing counselors and legal assistance. Housing counselors are one of the very few things that have been shown to really work. I think statistics show that when a particular homeowner has a housing counselor with he or she at the time of doing the getting the mortgage, they're 70% likely to be in their homes 6 months later, and if they don't have a housing counselor, they're 20% likely to be in their homes 6 months later. So it's a marked difference having housing counselors. The other, and that's sort of the money side. Now, this is the largest state-federal settlement in the history of our country. The federal government really came in toward the end and in a very big way. HUD Secretary Sean Donovan in particular was instrumental in making sure this got complete, as well as Tom Pirelli over at the Department of Justice in our Calder shop, to making sure all the states were on board and that this was an agreement that would be that would help the homeowners in all of our states. It is one of the very attractive notions of this is there were 42 pages of future servicing standards that were included in the agreement so that this kind of thing can't happen again in the future, which I think was very important to all of us and was a concession by the banks. Another attractive component of this agreement is that we as attorneys general have very limited jurisdiction in two areas. One are the national banks, another are credit cards. We're preempted. So we took a very small slice of jurisdiction and got a massive recovery for homeowners through this settlement. And we didn't give up anything, really. What we gave up are origination claims. Most of the originators are long gone, and most of the claims are, the statute of limitations is already told, and servicing claims. The robo-signing and such. But as I mentioned earlier, if a particular homeowner can show that there was servicing fraud perpetrated upon them, in particular, that is, but for the robo-signing, for example, they would not have been foreclosed upon, they have relief available to them. What we didn't give up, importantly, as I mentioned earlier, was the securitization claims, and Eric Schneiderman in New York and others will be bringing future claims. Any criminal claims they're still available to us. Any MERS claims for states that are able to bring MERS claims. Any civil rights claims or fair housing claims. So all of those are still available to us, and individual claims are also available. So we feel that we didn't give up much, and we gained a lot. The final point I'll make, and then I'll subside, is that unlike, say, the tobacco agreement, which was the last biggest thing that attorneys general did, and where here in Maryland, for example, we're still getting $160 million a year from that. This is the interests of the banks and the interests of the states are aligned. This is being overseen by a federal district judge in the District of Columbia, and there is a committee that is put together. A guy named Joe Smith, the former banking regulator of North Carolina, is the monitor. He has a staff, and they will make sure that the banks comply. The banks also have a financial interest in complying. So the total length of this agreement is 3 to 3.5 years, depending how you look at it, and it's done. And the banks have an incentive to get most of the money out, if not all of it, in the first year, because their penalties go up. And to the extent there's any money left that hasn't gone out by the last year, they have to pay hard dollars to the federal government. So it's that we think that's a very important aspect to it. It's enforceable, and the banks have the same interests we do. The banks are initially charged with determining who is eligible under the 3 different funds that I mentioned, the one for people on the brink of foreclosure, the one for people underwater, and the one for those who have already lost their homes, because the banks have the financial information. They have the information available to them. The problem, of course, is that many of these people have been running away from the banks over the past few years from their phone calls and their correspondence. So at the Attorney General's office, we're trying to make sure that we get the names of those people and call them ourselves and say, hey, we're calling from the Office of the Attorney General of Maryland. Your loan is serviced by Bank of America, for example. You are eligible to have a principal reduction. You need to call this person at this number as soon as possible and begin those steps using a housing counselor and getting that done. We're also, so those are sort of more the individualized identification and targets that we're going to do. We're also doing community events. I've done a few myself. We have a number already scheduled where we go to churches and different community centers, along with housing counselors and legal assistants there, to alert the community about this, because none of it's any good if people don't avail themselves of this money. So we're doing sort of a broad approach as well as a targeted approach to making sure people understand that this is available to them. We set up a hotline, for example, here at the Attorney General's office the first week after this was announced. We had thousands of phone calls coming in where we were able to direct people and give them information that they needed. The agreement has not yet been finalized, I don't think, as we're speaking. It should be, certainly in the next few days, and then the money will become available shortly thereafter. So with that, I'll subside.
Well, thank you so much, A.G. Gansler, for walking through that, and Jim for your presentation. You went through a lot of information that was very helpful in terms of what's in the settlement. And if I could just kind of summarize for our participants on the phone, we have a very large audience this afternoon. There seem to be 5 things that really popped out to me. The settlement mandates principal reductions, which is huge. This is not, as I mentioned in my opening, something that we've had available to us at scale. It creates rules to protect homeowners from losing their home to wrongful foreclosure in the future in terms of servicing standards. It provides funding for housing counseling, legal aid, and for victims. Again, really critical to get the infusion of funds to families and the nonprofits they rely on as soon as possible. You hit on a big one, A.G. Gansler, in terms of protecting the homeowners' civil and legal rights, which was just something that was very important, and as you mentioned, the securitization claims as well, and the enforcement provisions to make sure that the accountability and relief is delivered swiftly to the families and to the homeowners. So there's certainly a lot in here, and I'm sure that there's a lot of questions from our folks on the phone. So I want to remind people that they can enter their question to the right of your screen in the web chat, and I will see that and be able to relay questions. Let me start by kicking it off with my own questions while other people sort of gather their thoughts. Take some moderator's prerogative here if you guys don't mind. So A.G. Gansler, you mentioned something during your review of all of the things that your office is doing that was news to me, and that was that that claims for the Victim Relief Fund are due by July 31st. And I actually didn't know that there was a deadline on that. Could you talk a little bit about exactly how potential victims are being notified? Is there a formal, in addition to the outreach events that you mentioned, is there a formal notice going out that we should be advising our communities that they should look for?
Yeah, that's the only one of the 4 funds that has a deadline. Actually, the banks are going to send out the money, the different pool of money that is being directed by the Attorneys General in the second quarter of this year, which I guess we're in right now. So at some point this quarter, that money should come. The only the pool of money involving the principal reduction for those who are on the brink of foreclosure and the pool of money for the loan modifications for those who are underwater, those will be ongoing over 3 years, again, with the incentive being that people get that money in that first year. The one-time payout for those who have been foreclosed upon is the way they're doing it is the banks themselves are actually sending a claim form to the people who have lost their homes. Now, the problem, of course, is those are going to be the most difficult people to find because, by definition, they're no longer in the home that was serviced by that particular bank. So to the extent they have information on them, they will try and get to them. But that's why we're doing these community events as well, to make sure people understand it. And there's been, thankfully, a lot of press on the settlement that people will be able to contact their banks and get one of those claim forms. They have not gone out yet because the agreement hasn't been signed yet. But the thought, it's interesting, there's a lot of distrust of the banks, and that's understandably the case. But they expect about a 45 to 50%. This is literally free money. I mean, there's, but for the Attorneys General doing this, well, none of this would have happened. But for the Attorneys General doing this agreement, certainly the people who have already been foreclosed upon would not be getting this check. And again, it doesn't compromise any of their other rights at all. It's just the state's interest, which is somewhat limited in this case anyway. And yet, having said that, there's an expectation from sort of past situations like this of about 45 to 50% of the people availing themselves of this opportunity. And that is why the estimates are what they are for the payout. So they're going to give them, 3 or 4 months to locate the people. We're going to do the mass outreach and try and get these people. But then at the end, at July 31st, they then collect all of them. They take the $1.5 billion basically and divide by the number of forms they've received, and that's how much money everybody's going to get in their check. So they wanted to do it that way so that everybody would get the same, whether you live in Louisiana, North Dakota, or the great state of Maryland, you're going to get the same check.
Right, that makes sense to me. So another question that I have for you is how this will interact with the other settlements. So as you alluded, this is really just one settlement on one issue, and I think Jim mentioned this as well. One settlement is not going to cure all the ills out there. And there's a couple of other major settlements that have been a big step forward in terms of accountability and relief. One that's not as related but still worth mentioning is the DOJ countrywide settlement. But the other that maybe is more related is the OCC's independent foreclosure review, which similarly has a major outreach effort attached to it. How do you see the two settlements working together to bring relief to families?
Well, the countrywide was something that all the AGs, including our office, got involved in, and there was recoveries there. We've also been involved in a number of other, bad times bring out bad actors, and so there's been a number of foreclosure scams. In fact, I should mention, I know, and I'll get to your question because I actually don't know the answer to it, but there've been some other. One of the concerns we have are people that are not housing counselors getting the names of the people who are eligible for this money and calling them and saying, hey, we think we can get you principal reduction or loan modification. Give us, $1,000, and we'll contact the person. We'll work with you in the Bank of America. Well, those are scams because there are ample housing counselors available and willing and able and that want to help folks to do exactly that without taking their money and either actually performing the service or taking the money and not performing the service. So we're very wary of that as part of the agreement. But we've also gone after, example, here in Maryland, we went after a Ponzi scheme called Metro Dream Homes, where the person was just sentenced by the Department of Justice. We did the civil side, they did the criminal side, to life plus 76 years or something like that. So that's sort of part of this too. We're not giving up on other arrangements. In terms of the OTC one, I just don't happen to know about that one. We don't, that sounds like a federal agreement that we weren't really part of.
And somebody else just, a participant by the name of Kate Berry is emailing or is chatting about this same question. And the thing about the independent foreclosure review, I know you're not directly responsible for that, but it only does the look back on loans in 2009 and 2010. Do you know whether there's any effort to get regulators to look further back to 2006, since that's when many minority homebuyers got subprime loans, or they went into foreclosure before 2009?
I think there was a lot of discussion as to how far they could go back and be able to identify the particular cases, and they decided on the deadline they did because the interest here was try and solve the problem. That in other words, people going back to 06, 07 have the same rights they had before all of this, but there was a strong interest in trying to get a lot of money from the banks and keep, on the one hand, but also to keep people in their homes on the other, and to stem the foreclosure crisis, begin to stem the foreclosure. This is not going to stop the foreclosures from occurring, particularly since there's so many of them that are Fannie and Freddie loans, which we have as limited jurisdictions as the Attorneys General have in this arena in the first place. We have no jurisdiction over Fannie and Freddie. We're hoping the federal government is doing that. And we do think that the servicing standards as part of this agreement will be the model Fannie and Freddie going down the road. But we are the ones that began in '08 are the ones that we're really focused on because those are the people that are at most danger of losing their homes. So I think that was what the theory was.
Thanks. So the questions are rolling in here. I'm going to group two of them together for you and keep you on the hot seat, AJ Gansler. So one theme that's coming up in the questions is around accountability. We've got Araceli Panameno and Robert Strupp who've asked some questions about how do we know and how can we trust the banks who have really violated our trust in many different ways? How do we know that they're going to honor the settlement? And then there's another question here about whether or not the settlement is enforceable yet from Miritana. And I think I heard you say that we're still waiting for the final consent order to be signed, but maybe you can clarify on that piece as well. So the question is really around enforcement and accountability of the settlement.
Well, you'll be shocked to know the attorneys general share the distrust of the major banks, particularly since we're privy to, through our subpoenas and so forth, a lot of what it was that they did. And you know, the zippy cheats and tricks, I mean, all this stuff that they were doing was absolutely incredible. And I mentioned at the outset, in particular focusing and targeting on the minority community. So we were extremely concerned with that very issue of accountability, which is why it was, it is going to be filed and finalized. It's been filed, but it hasn't been finalized in federal district court in the District of Columbia. We have been told, though we're not, I don't think that it's been finalized, that the chief judge himself is going to be the judge overseeing this, and he could not be a better, more fair and judge. So that's a piece of it. And then the monitor, the monitor Joe Smith, who is the banking regulator of North Carolina, and his staff that he's putting together will make sure that this happens. And as sort of the last fail-safe is that if it doesn't happen, the banks are going to pay an extraordinary amount of fines and penalties. So, you know, and they, you know, I guess you kind of flip it to, you know, sort of why would the banks do this? You know, why would they give out $26 billion in relief? You know, particularly in an investigation led by attorneys general who don't really have jurisdiction over them. And the answer is that they kind of wanted to go forward too. And you know, there is a value to them, one could argue, in keeping people in their homes, because then they're getting monthly payments, albeit smaller than they think they're entitled to by the contracts that they reached. But of course, there were fraudulent aspects underscoring those contracts in the first place. But those monthly checks are still going to be larger than zero, and getting no money and having to put the house up for sale and increasing the inventory of empty houses. So, you know, there was sort of, they have an incentive to reach this agreement as well. So, but the real answer to the question is, there's a federal district judge working with a monitor and economic incentive to make sure that this is going to happen and is ironclad.
That's helpful. So we have a lot of questions from several different participants asking about when relief will be available. You know, you mentioned, you know, everybody's eagerly waiting, but can you speak to that specifically? Yeah,
you know, it was supposed to have been filed in the last week or two. I don't know exactly what the what the holdup is. There are some rumors, and you know, there's a lot of press, so you can quote me, but you can quote me as being a rumor that they're trying to get Oklahoma involved, sort of the 50th state, to sort of get this all behind us. It's unclear what the holdup is, but it's been finalized, been agreed to. It's with the judge, and it's our understanding that it'll happen. It's going to be filed, in short order, in days, not weeks. Once that happens, they'll start the process of sending out the pool of money to be directed toward housing-related projects. And the reason why that's important is because most states are going to be enhancing their housing counselors and legal assistants. Here in Maryland, for example, we have something called HOPE, which is run by the state, and there's 32 to 36 housing counselors statewide. Well, that number one would think needs to be significantly enhanced, and then so once that's enhanced, it makes it easier for people who are eligible to go to the housing counselor and get their help getting their principal reduction or the loan modification. But right now, some of the banks are starting to actually begin this process of the reductions, but most are waiting until they can actually write it down. Once it's filed, for example, in Maryland with the $808.5 million to go to people on the brink of foreclosure, that number technically and legally under contract theory would not start to be reduced until the deal is finalized. So we're getting the information now. We're getting names of people who are eligible. We're getting their contact information. As I said, thousands of people have called here. Thousands of people have called that HOPE service. So once this is filed, we can reach out to them because they've heard about it through our community meetings or through the press and understand that they have money coming to them or write-downs coming to them.
So again, the questions are just pouring in, and they're all very good. I want to thank all the participants for getting your questions out there. Let me again attempt to group a couple of them. So one I think here is pretty important. It's a criticism of the deal that we'd like you to address. This comes from Jeffrey Dillman. It says, as the New York Times noted in an article last week, banks can get credit under the agreement for actions they're already undertaking. And the former Deputy Chief Counsel for OTS called it a sweet deal for banks. Can you talk about that a little bit?
Well, it's easy to say, and there's been a lot of criticism, and people are outraged. Even at these meetings, these town meetings, people are, the banks did this, this, and this, and they should be, they should give them a house back. And I don't think there's anybody out there that's, well, except for the banks. The rest of us are extremely sympathetic to that sentiment and understand that what the banks did was wrong. And this is a first step. And I think everybody in the Attorney General world, at least, views this as a first step toward getting relief. But it's an essential first step. It's easy to sit back and criticize something, but if you look at the amount of money, I mean, in our small state, we're getting almost $1 billion imminently and directly to homeowners, as opposed to, somebody kills somebody. And it's always been, I've been a prosecutor for 20 years, and what should the sentence be? You're not bringing the person back, so what's an appropriate sentence there for the conduct that the defendant did? Well, here, I think one of the very attractive pieces of parts of this deal is that the penalty goes right to the homeowners themselves. It doesn't go into some money pot. It goes right to them and helps them get relief. So I think while people will criticize it, you also have to look at what the scope of jurisdiction attorneys general have in the first place in this arena, which is very, 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 very limited. And if you look at what we gave up, which is just the origination and servicing, it's almost impossible to find most of the originators of these deals. And to the extent you have, they really have the statute of limitations is run. So we really have no recourse there. And in servicing, I haven't met the person yet. I'm sure they're out there, but we haven't met the person yet who, but for, say, the robo-signing or other servicing failures of the bank, but for that would not have been foreclosed upon. Now, they may, I'm sure they do exist, and those people have completely the same recourse they did before this agreement, but since there aren't that many of them out there, if there are any, the fact that they're getting, in Maryland, $960 million in relief, I would suggest is a pretty good deal for the people. So, people will criticize it, and again, I think you have to emphasize this is a first step. I mean, the securitization claims, again, you're going after a different target. You're not helping homeowners, you're helping investors. But I do think, I mean, Eric Schneiderman and I have been in contact quite often. He's been the president put him in charge of this new committee that's looking into these claims, and they're beefing up with staff. And I think you're going to see a lot of securitization claims coming down the road. I think a number of states, we all have different access to MERS availability and ability to bring MERS claims. Massachusetts, Martha Coakley has brought her case up there because she has the ability to bring MERS claims. So I think you're going to see a number of other things that happen. Missouri, as I believe, has already brought or certainly has suggested they're going to bring some criminal actions. So I think you're going to see a lot more claims down the road.
That sounds. Thank you. Okay, so I'm just being mindful of the time here and noting that we have many, many questions. So we're probably not going to be able to get to all of them, but for those of you on the phone, we will try to respond to your questions if we can, follow up with you offline. But let me get a couple more in here. One question that has come up a couple of times is that we know that some AGs have already stated that they're not going to use the funding that was supposed to be designated for housing counseling and for legal aid for those purposes. You mentioned that about 10% will go into the general fund. That leaves 90 for this other use, and it sounds like Maryland is working heavily with the housing counselors, which we thank you for as a housing counseling intermediary, and there's many counselors on the call. But what about the AGs that are not honoring that agreement? Is there something to hold their feet to the fire to make sure that those funds go to those nonprofit resources?
Just public ridicule. That's all. You know, it really is. You know, there's nothing contractually that says they have to do that. You know, but it really, and Secretary Donovan and I had a event out in Maryland a couple weeks back on this very subject because, you know, this whole thing was put together because the banks took advantage of people in their housing. And this isn't like, you know, the repo man coming and taking your television. This is families losing the most important asset they have, their homes, and kids, you know, coming home from school and finding their house has been foreclosed upon. I mean, it's and in large measure because of the sort of pervasive conduct of the banks. Yet some of the AGs, and they're not, you know, they're who you would think they would be, think that it's appropriate just to turn this money over to the general fund for pet projects of you know, government. And I think that's inappropriate. But each state has, you know, I also think it certainly violates the spirit of the agreement. Each state has a sort of a different way of doing it. I know Tennessee, for example, has the same or similar laws that we have in Maryland regarding penalties. So when we, at the Attorney General's office, we bring a lawsuit against a company, we get, you know, we get restitution for victims, but we get a fine or a penalty. We're required to hand that over by law to the General Assembly. This is different because this is not a litigation. This was not money that came to the state. It's a very different animal altogether. That said, it does specifically delineate that up to 10% of the money for that particular pool can be considered civil penalties. That's why we felt it was appropriate to give the entire 10% in Maryland to the General Assembly, consistent with our laws, but also consistent with the letter of the agreement. We also thought that it was important to give the other 90%, not just to housing counselors or legal assistants, though the committee may decide that's where all the money should go, but to a number and a variety of housing-related projects to help folks.
So let me see if I can squeeze in one last question here. This has come up in the questions that I'm looking at in a couple of different ways, but the question is ultimately what sort of relief might be available for families that are current on their payments. And it might surprise you to know that this far into the foreclosure crisis, families still get advice from their servicers telling them that they have to default on their loan before they're eligible for any sort of support, even though that's not the case for many of the programs out there. But that's still common advice that we hear from servicers. Is it necessary under this agreement that families be delinquent, and what might be available for families who are underwater but have been struggling and making it work and making their payments?
Well, that's the pool of money that in here in our state, for example, is the $64 million pool, and it's precisely for that. And you know, people have called their servers and they say, well, we're not going to refinance. We're not going to give you the lower loans because your loan is so much greater than the value of your home. Yes, we appreciate you making your payments, and then some people say, well, you just walk away from it. So what we're trying to do, like in the principal reductions, for example, they want to get them down, the folks down to the principal being 120% of the home. That's what the studies have shown will create the proper incentive for people, and obviously the payment itself is lower significantly because the principal's been reduced. The same with the loan modifications. You want to get it down to where the people in the homes who are up to date have an incentive to continue to pay, but also it's a lot easier because their loan's has been modified to reflect today's interest payments, and they have an incentive though to maintain that because A, no one wants to be foreclosed upon, but B, it affects your credit rating and other things to be foreclosed upon. And one of the things we want to stress for legal assistance is that some people, as a result of being foreclosed upon, have their credit ratings, their credit ratings have been damaged as a direct result of what happened here. We want to make sure that if they haven't had other credit issues, that their credit rating is restored so that they don't carry this with them in the months and years to come. So there's been a lot of people at these meetings that we have, the outreach stuff, say, well, I called my servicer and they said they won't do a loan modification. Well, that's right. They won't do it until this thing's signed, and then they have to do it under the force of the agreement.
Thank you. So I know I told you that was the last question, but I'm wondering if you will be generous and take one more.
Sure.
Okay. So I actually want to hand it over to our co-panelist, Jim Carr, and give him a chance I think he has a question for you as well. Jim?
Yeah, sure. Thank you, Janis. And thank you, Attorney General Gansler. You've given us a lot of information. So a couple of quick questions. So forgive me if you've already addressed them because, again, you've given a lot of information. But as our focus is on communities of color, I'm wondering whether there is going to be any tracking of loan modification and making available data such that we can immediately see the race, ethnicity of the borrower and or the community types that are receiving the benefits of this agreement.
I don't think there's any plans as such to do that, though if any individual state wanted to dedicate a portion of that pool, that certainly would seem to me to come under, it's a very broad definition of what's housing related, and that would be housing related. We know, I mean, we don't know the number precisely in Maryland, but we know that this was, disproportionately in a major way impacted the communities of color because, we happen to have here in Maryland the richest African-American jurisdiction in the country and probably the world in Prince George's County. Yet 1/3 of the foreclosures in Maryland actually occurred in Prince George's County. And the second biggest hit was Baltimore City, and these are predominantly minority communities. So we know that that communities of color were disproportionately affected by the foreclosure crisis. What the exact numbers are, we don't have any intention of studying that, but I suppose there would be ways to do it, and maybe our committee does allocate some money toward a study of that. It would be sort of interesting to know to what end, because we do know it's not a mystery to us. That's who the banks were targeting. And so we know that that's what was going on here. Now that might be a different analysis in North Dakota. I just don't know.
Right, Attorney General, I appreciate that because, as you said, the disproportionate damage occurred in communities of color, and I think that's one of the concerns of everybody on this phone who's focused on communities of color is that the agreement doesn't necessarily require or mandate or dictate going to those communities. So the only way we know how effective it's ultimately going to be for communities of color is if we have readily available data. Another quick question, as you know, the mortgage debt forgiveness tax provision expires at the end of this year, and I'm just wondering whether you would support its extension, and do you think other AGs would, to be consistent with the the term of the agreement, I believe, 3 years.
The federal agreement?
Yeah. Mm-hmm.
Yeah.
Federal.
Yeah, I mean, you know, no, we've been sort of focused on this, as you can imagine. I assume, you know, the kind of nice thing about one of the things that's been good about this particular agreement is it's really brought the issue into our bailiwick, and so I think that it was certainly something we would consider. You know, we do things kind of by state, but if we do get 36 states to agree to something, like, for example, a letter in support of the extension, then that would be a NAG proposal. Otherwise, it would be the individual states either doing as individuals or collectively, but not as a NAG proposal as under 36. But that's something I don't believe I've been asked to weigh in on that at this particular point. But that's something that certainly we would look at and consider.
Okay, and just
so
real
maybe
quick,
another. Oh,
I was just going to ask.
Jim, go ahead, Jim. I'll pipe in after you.
Okay, just very quickly, one last point was that, you know, the flip side of the loss of wealth from the foreclosures is the tightening of underwriting to the point where people of color really are having a difficult, if not impossible, time getting into the homeownership market. And when we talk about REO, you know, one of the most frequent conversations in the press is about how different agencies and institutions are encouraging investors to buy properties, as opposed to looking at, you know, the extraordinary drop in home values and home prices, and looking at whether this is the time to be innovative in looking at ways to broaden home ownership through creative programs such as lease purchase, that sort of thing. And I'm just wondering if your understanding of the flexibility of any of the funds you have, again, you went through them very comprehensively. I just couldn't put the puzzle together. Whether you think there's an opportunity, for example, for state AGs, including yourself, to look at something like REO programs that are focused on lease purchase rather than having investors buy properties.
Yes. You know, that, I know that's one of the things that, for example, the committee is discussing, how much money would make an impact to do things like lease purchases and other types of, you know, above and beyond. That's why I have no mandate for them. I said, look, you guys figure out, here's, you know, this is the amount of money we're allotted for this one pool, you know, which I think is the least, in some ways, you know, it's a very different animal than the other 3 pools, which is going right to the people that need it. But, you know, I said my own view is we should dedicate some of this money to housing counselors' legal assistance. Whether that's 10%, 20, up to 90% of the money is really up to them, but they're considering all options, including things like lease purchases, which would help the housing market and people in particular. So, yeah, that's something they're going to consider. But again, different. The only 2 states I know that are doing it the way I'm doing it with the committee that I'm not part of, you know, they're going to end up having recommendations to me, is Colorado and Maryland. Now, I just don't happen to know what other states are doing. And, you know, some states aren't giving a nickel to the general fund. Some states are giving all of it to the general fund, which we mentioned, which we find problematic. And others are sort of making decisions based on what they know. But everything's sort of on the table.
Okay, thank you very much.
AG Gansler, I want to thank you so much for being so generous with your time. We're actually a couple of minutes past the hour, as well as the participants who hung in there and sent in all of your questions. I want to wrap up by underscoring Jim's point about the importance for communities of color of tracking the outputs and the administration of the benefits of the settlement by race and ethnicity. And actually, in a recent presentation that I heard Joe Smith give, I think he's interested in working with the AGs and with the banks on how that might be able to happen. And so perhaps, AG Gansler, we could follow up with you about how your office might be able to maybe make a recommendation to this effect or something. There is quite a bit of concern amongst folks on this call and advocates in general that the benefits will flow to those who are easiest to do principal write-downs, and hard-hit communities that are also harder to serve will get left out. And the only way we'll really be able to make sure is by having the data and the transparency in the settlement. So perhaps that's something we can work together on moving forward.
No, absolutely, and I think it's an admirable pursuit. I mean, particularly nationally, I think it's less of a concern in Maryland because we have, the 960 million, and most of it's going to communities of color because that's who live. We happen to have the highest, highest percentage of African Americans in the country outside of the deep South. But I think it would make certainly where that's not the case. But here as well, it doesn't hurt to say it, here as well, that would be a good idea. And the best place to do it would be through Joe Smith and the monitors. I mean, that's because they're sending out nationally rather than each state sort of devising its own studies. It would make sense to do it on the national level, and we definitely would be supportive of that. So I think that would be great. And I just want to, in closing, on my side, thank you for doing this. I think it's, not only is it important to discuss the impact on communities of color, but we want to make sure that everybody gets the information. This is yet another way to get the information out there to communities of color and everyone else. And I want to thank Maya Rockymore for setting this up and getting me on here. So appreciate it very much, and hopefully we all learned a little bit.
Absolutely. Well, we're all in debt to Maya Rockymore, who did fabulous work, as well as Ann Price and the team over at Insight Center. So on behalf of the whole crew, I just want to thank you again, thank our participants, thank you, Jim, and we will conclude here. Thank you.
Thanks. Bye.